Welcome to Divorce TV. I'm your host, Wally Marcus. Our topic today is divorce and fault, and a very special guest is an old friend of mine from Connecticut and one of the really top divorce attorneys in Connecticut, if not the country. When you were actively practicing, and probably, I guess that doesn't go away, that title, is Arthur Balbirer. Arthur, welcome. Thank you for coming on and being on the show.
Thank you for those kind words.
Well, we're not opposing each other. Actually, Arthur, you're the first guest I've ever had who I've been on the opposite side of a case with, so we're not going to go there.
No.
You were much more experienced and better attorney than I was at that stage. But now we're both mediators and doing different types of mediation, so it's good. But Arthur, can you tell us a little bit about yourself?
Well, I started practicing law in 1966 in Bridgeport, Connecticut, in by Connecticut standards, a reasonably large litigation-based firm. Everyone above me hated divorce work. They used to call it domestics. And having received a master's in psychology, they thought that would qualify me to assist them with these obviously distressed and emotional people. And also their desire was paramount that hopefully a second chair, these people would get sick of them and they could turn them over completely to me. And so over a course of 32 years, I essentially did nothing but divorce work and was involved organizationally with the American Academy of Matrimonial Lawyers, and at one point was president of it in 1992, and was involved as chair of the Connecticut Bar Association's family law section, and wrote for an annual survey of Connecticut family law. So I've done a lot of family law work. And in 1998, I stopped practicing law in seeing clients, but got involved by reason of a couple of judges asking me to in doing mediations in certain cases that were daunting to them and which they needed some help. So I kind of reinvented myself, and I've been doing mediations, evaluative mediations, with lawyers and clients since that point, and also the occasional arbitration.
That's interesting. Did you ever take a course in family? I assume you took at least a course in family law in law school?
I did, but it was
took
more,
one course.
It was a glorified conflicts of law course. It really had very little to do with family law.
That's sort of interesting. I mean, they're really a lot with the clinics now and everything else. I think the legal education and with the women in law school on a much higher level than when we were there. I think things have changed.
Well,
although I can tell you, my law firm when I started, I would not do a divorce. It was dirty work.
It was dirty work back in the day. But getting back to law school is not many women were in law school when I started out. I was in a class of 300 at NYU Law School, and I believe there was no more than 2 women in the law school.
I was a few years after you, 72, and there was 156 in my class at the University of Connecticut, 12 women, although Andrea Guinness, who we went on to be a judge and a few other people.
Chief appellate court judge.
And some other, actually some domestic attorneys went on to do it that well, too. We're talking about fault, and I think that comes up a lot in divorce cases. I'm not sure it's a well understood concept of fault, and now you've been on the forefront of the change over your course of your legal career from fault to no fault. Can you give us a little bit of the history of fault, no fault in 10 words or less?
Sure. Until 1970, in order to get a divorce in any of the 50 states, maybe Oklahoma was an exception. They had some limited no fault. You had to prove conventional villainy grounds to get a divorce. In other words, one party had to be the bad person, the other had to be virtuous. And in fact, if both parties were guilty of grounds, the law of most of the 50 states stated that neither could get a divorce because back in that day, there had to be clean hands. And if one party had clean hands, they could get a divorce if they could prove fault on the other side. If both parties were guilty under the doctrine of recrimination, the court stated neither of you could get a divorce, and that resulted in what we used to call Mexican standoffs, which meant that in order to get a divorce, you had to resolve the financial issues and the custodial and go to Mexico and get a divorce because you couldn't get it in your home state. 1970, California was in the forefront and passed essentially our country's first no-fault divorce. Irreconcilable differences was enough to get you a divorce. Over the course of time, a number of states followed suit, as they did back then. California was usually in the forefront of an evolution in law. And in 1973, in October of 1973, Connecticut got a no-fault divorce, which meant that in order to get a divorce, you didn't have to prove the villainy of the other side. Interestingly, Arizona, 6 weeks prior to that in 73, also got their first no-fault divorce.
I mean, we deal with this all the time, but what is fault? What is no fault? I mean, what is...
The traditional grounds to get a divorce would be that you had to prove that the other spouse was guilty of adultery, or intolerable cruelty, or habitual intemperance, or physical abandonment. There had to be, or conviction of a felony. In other words, bad conduct.
And how did that work if that didn't exist?
One of the reasons we were able to convince legislatures to pass no-fault divorce was to give them evidence of the fact that people were conjuring up grounds, and there was a lot of perjury going on in the courtrooms and in the courthouses, and that wasn't acceptable. It was destroying families by having people having to throw stuff against the wall in order to get a divorce.
And what about what's no fault then?
No fault means that in order to get a divorce, you don't have to prove fault.
What do you have to prove?
You have to prove that the marriage has died, that it's irretrievably broken down, or that there are irreconcilable differences, that you do not have to prove conventional bad conduct to get a divorce, nor do you need the permission of the other side to get a divorce.
I'm sure you've come across this, because I came across it all the time, where one person would say the marriage hasn't broken down, and one person says it has.
Well, that's very, very rare. I think.
Well, maybe they're feeling. I'm not sure.
Well, they may be feeling it, and there's a great deal of disappointment. Lots of litigants are disappointed when their spouse has brought an action to dissolve the marriage. Even the word divorce isn't necessarily used. It's far more feely-touchy to refer to it as a dissolution of the marriage. But there are people who are disappointed when an action is brought, and who might say to their lawyer, "Hey, I want to fight this. This marriage isn't dead." Unfortunately for them, a court usually will feel, if it goes that far, at some point they calm down and they'll accept it. Time heals all wounds, as they say. But judges feel as if an action is brought to dissolve a marriage, that's pretty convincing that the marriage is dead.
Yeah,
at least one party thinks to a two-party marriage feels it's dead. What could it be? It can't be alive. So it's rare that somebody's going to fight against that. They grow to accept it if they don't like it.
Have you seen cases in which, where even with no fault, people still bring a fault?
They do.
And why?
They do because in some states, fault. Well, I'll give you an example. Connecticut, and understanding that divorce is a creature of statute, and all of our 50 states have different laws of divorce. Connecticut, in order to get its so-called no-fault divorce statute, had to agree with the people who were firmly opposing it, namely the Catholic Church, to be honest about it, had to agree that the cause for the dissolution of the marriage would be relevant in determining the financial resolution and in the custodial aspects of the divorce, so that that the cause for the divorce is not necessarily fault. Somebody could be guilty of fault, but if it wasn't the cause for the dissolution of the marriage, technically it wasn't relevant. In Connecticut, at least, and in those states in which it is still relevant as one of the laundry list of factors that in the issue of financial resolution and in custodial resolution, showing why the marriage broke down and that one party or the other was particularly egregious in their wrongdoings might convince a court to take that into effect and to make their orders accordingly. And so it's still used. As a matter of fact, fault many times, or the cause for the divorce or dissolution of marriage, the irony is it's used sometimes more now than it was when we had a fault.
That's what I was going to ask you about, because it seems to me when my reading on this, I started practicing just when this was happening. I'm going to come back and tell my no-fault joke, actually, that people would just, say these things or do these things, and it was sort of a crazy situation, and it would influence the case.
Well, one of the things, as I mentioned earlier, that you were concerned about back in the day when you had to prove fault is if you put too much fault in, the other side, as a reaction, would put their side of the fault in, and the judge would find that both parties were guilty of grounds and give a divorce to neither. And that's what I meant when I was talking about a Mexican standoff. And that was the doctrine of recrimination, that if both parties are guilty of grounds, neither party could get a divorce. With the advent of no-fault divorce in a state like, for example, Connecticut, you could, with impunity, throw grounds in order to try to get a better financial resolution.
But I guess what I was going to say is that the underlying theory on no-fault was that it was going to make it less adversary.
That's correct.
And although it's interesting, you and I have watched a lot of things that have come in as reforms in divorce and don't seem to work that way. But it hasn't really.
You're absolutely right, because I think there's probably more fault that's injected in cases in an attempt to convince the judge that the financial resolution be altered by reason of how bad their spouse has been to them.
Do you really find it's interesting when we're talking about fault? Is that, and with your experience and also what you're doing now, is that are the judges influenced, do you think, by fault?
Interesting. Some of them, many of them say they're not. Many of them say, listen, there are 16 factors that I'm supposed to take into account, and I can tell you right now, and they say this in chambers, if they don't say it right from the bench, that's number 16 on my list. You have the right for me to take it into account, but I'm going to tell you very candidly, I don't care about it. So go ahead. Now, some of those, and they do that because they really don't want the case to get off the track. They're interested in those other 15 things. But what's interesting is some of the judges who made those statements sometimes would make orders which could only be explained by reason of how offended they were by the conduct of one of the parties. I have a couple of stories about that we don't have time for. So judges usually like to discourage fault being thrown into it, but they're not particularly successful because somebody has a story to tell, they have to tell it, and the other side, they're not worried about Mexican standoffs anymore or recrimination. They have an obligation, they feel, to respond in kind. Yeah,
I said I've seen some cases where I thought I had slam dunk fault cases, and the judges seem to not care at all.
But, that's correct. By the way, Arizona, from what I understand, they don't have the cause for the dissolution as a relevant factor in the financial or custodial issues, but they do have a certain amount of fault. For example, if one of the parties is dissipating assets, spending it on a boyfriend or a girlfriend or something like that, that evidence will be listened to by the court in fashioning its orders.
Well, I think interesting in Arizona is, and we've talked a little bit about that before, is covenant divorces. Covenant marriages, not covenant divorces. And I've yet to come across a covenant marriage, but I mean, essentially where they reintroduce fault in order to get the divorce.
Well, the covenant marriage statute in Arizona, and I think it's like 10 years old, basically says that the parties agree that they will not bring a divorce against each other, because marriage is forever, unless one of the conventional fault grounds is the foundation for their action. And it goes on to speak that way in the statutes in Arizona. But it's also interesting because one of the things that's also said in the statute is parties to a covenant marriage who decide to get a divorce can also dispense with fault if they so agree at that time.
Yeah, I just never have yet to come across it.
Interestingly, because I know a lot of very prominent divorce lawyers in Tucson, and they have never had a covenant marriage divorce.
Check it out.
It just isn't. I don't think people are
wanted to tell you the story earlier, and I think I've told you a long time ago about fault, which always, because I was an intern at Legal Services in Stanford back in just before, I guess in 72, so just before no fault came in, and this lady comes into the divorce. I wish I could remember the name of the judge. It was 400 pounds. And at that point, they had to, bring the two witnesses in, and they had to say, and they would, I'm not sleeping, I'm losing weight.
Gaining weight, losing weight.
And this lady's 400 pounds, and she says, I'm losing weight. And why she chose that, I have no idea. The judge leans over to her and said, you should stay married a little bit longer.
Yeah, that's pretty feely-touchy, Judge.
But we do that one. There's recently an article in the New York Times about England and their fault, which they finally, it sounds like, are moving towards. And for many of the same reasons that you've sort of been discussing.
It's fascinating to me because they're the bastion of common law as we know it, and they're an enlightened people, and yet here we are in 2012, and it's finally coming to them that they should have no-fault divorce, as opposed to the conventional divorce that requires grounds and the proving of villainy. So that surprises me, to be honest with you. But there are other
Why?
things. It surprises me because they are an enlightened people. And all of our 50 states have no-fault divorce. South Dakota and New York being the two last ones. But the big majority were in the early to mid-70s. You're talking over 30 years ago. And for England to first be coming to the conclusion that proving fault is not in the interests of families or the public in order to dissolve a marriage, it surprises me it's taken them that long. But there are other aspects that I'm aware of in which they are a little bit behind us, like dealing with pensions and other things.
The question that you sort of started saying about the different state jurisdictions is a question I've always wanted to ask you, actually, a little bit off topic, but do you think there should be one federal or one statute, and we're involved with all this crazy healthcare stuff now, it just seems that people can forum shop. I remember in cases, for instance, when we were practicing in Connecticut, because of how marital assets were defined, the huge difference in between whether, the results of cases.
Well, first of all, it's a product of state law. As I said a little bit earlier, divorce is a creature of statute. It was unknown to common law. So in other words, it is based upon what the state legislature has affected. And each of the 50 states' laws are a little bit different. Some are very similar and some are very, very different. There is no such thing as a federal divorce.
I understand that, but do you think there should be more of a nationwide standard?
I don't see a reason for it. I don't see any reason why it should be taken away from the states to determine, based upon their citizens, what should go into it. We have a very diverse population around America, and I think that local divorce laws should be left up to local.
Because it's interesting. It is fascinating. I want to do a show on that someday. Each of the states vary tremendously in terms of
they do
of what
Just in
you
the
want
definition.
To get if you're a guy, you want to get divorced in Texas.
Well, just in the for sure. Up until recently, in Texas, you couldn't get, and it was a no-fault state. No alimony could be awarded. Yes, there would be property division, but if there were no property and a guy was a big wage earner, his wife of 30 years, who was reliant completely on her support and her style of living for that 30 years, she couldn't stop the divorce and she couldn't get alimony. And they've changed that, but it's still, I think there's a limit on the amount of alimony that can be given, and both in amount
plus
and
a jury
duration.
trial, potentially.
Potentially a jury trial.
We're talking a little bit about fault, and I'm not sure we totally answered this question, but it seems to me there's two ways the fault comes into it. One fault is that whether you get divorced or not divorced, but then the other one is how it affects the
financial and custodial issues.
And some of the states, certainly vary on that. What's the...
I would say to you that there are a handful of states, Connecticut being one of them, in which one of the many relevant factors to be taken into account in the financial resolution is the cause for the dissolution of the marriage. I would say the lion's share of our states do not have that in their law. And we did it because it was the way we were going to pass the law. And it was our intention, by the way, once we got the law, so-called no-fault divorce through, that in several years we would then even get rid of that remnant.
But you wanted
we never
that,
did.
You wanted it at a time. Do you still want that? I think that
No.
you've changed your position on it, haven't you?
Yes, a lot of people did. We've had the opportunity over the many years to remove that remnant. But, a lot of people believe that, something, it shouldn't necessarily be dispositive. But shouldn't a judge know why a marriage died? If there was a particularly egregious wrongdoer, shouldn't the judge know about it? Not necessarily that it be dispositive of the case, but maybe the judge ought to know about it. Judges have, they're human beings, and they put their pants on, so to speak, one leg at a time. They have their own baggage, and certain things are going to affect certain judges differently than other judges. I have a number of anecdotes about that, but we don't have the time.
Short anecdotes we like.
Well, one of them was I got a call from a national reporter of a woman's magazine, a national woman's magazine, saying what effect does adultery have on a judge's determination in the award of alimony or an equitable distribution. And I said, listen, I want to make it very clear. I'm a Connecticut lawyer. Your publication is going nationally. And as a result of that, please understand, I'm only talking about Connecticut, but in Connecticut, a court can take that into consideration. Different judges will take it into account differently. Some judge, it depends upon what the baggage is of the judge. Some judge may have a daughter whose son-in-law has just left his daughter for another woman. and he may not be very nicely inclined. Some judges are having affairs themselves, and I went on in that vein. The article came out that Attorney Arthur Balbirer states that since the judges commit adultery routinely, that it doesn't impact their. But that's one of the problems sometimes that you deal with with the press.
I know it's hard that way.
But it's a question of baggage, and it's a discretion within judges as to how they're going to deal with all of the factors that they have available to them. How are they going to deal with them? Some judges will take the same set of facts into account more prominently than another set of judges will, or set of facts.
Can you actually either go for a no fault or a fault divorce in some states?
I think that you still can bring an action and predicate the grounds based upon adultery or intolerable cruelty. In some states you can do that, as opposed to availing yourselves of claiming that the marriage is broken down irretrievably. I can't conceive of why somebody would want to do that. They still, even if they brought the action on the basis of irretrievable breakdown, they'd still be preserving their rights to offer why the marriage did break down in those states in which that's relevant, as, for example, Connecticut.
How do you prove it? It's broken down. If it was a contested divorce and they were saying...
There's very little proof that's required, especially if the other side isn't going to do anything about it. We spoke briefly about the fact that there may be somebody who's disappointed that the divorce action is brought, feels the marriage hasn't died. There are protections, by the way, in many statutes for one of the parties to get mandated conciliation. And all you have to do is go on several occasions, and that's it, and it's over. It's very rare that somebody is not going to ultimately throw in the towel. They still may be very, very angry when it comes to the financial resolution, but proving irretrievable breakdown is very simple, and it's usually composed of one party simply being asked, is your marriage broken down irretrievably? Answer, yes, it is. Are you living separate and apart? Not that that's required, but it's just a little bit of overkill. But it's no real big deal in order to prove it, especially if the other side isn't opposing it, which most people don't.
You've been practicing enough to see both sides of this thing. I mean, you're basically satisfied with, having seen it before no fault, after no fault?
I think that it was devastatingly bad for families to require a villain in order for a marriage to be terminated. I think that it encouraged perjury. I think it made somewhat of a joke and a farce out of our judicial system. I think it was a bad thing to require it. And I also believe that it also put certain people over a barrel financially. In order to get a divorce, many times for the other side to agree, you had to agree to their financial terms, and it was kind of like a legal hijacking or ransom. And sometimes desperate people, in order to get the divorce, would make very improvident financial deals which hurt not only them but their children. And so I just think it was a bad thing to hold a marriage in hostage over financial issues and vice versa.
What would you do if you wanted to improve on what we've done in terms of fault?
Well, I believe, because I grew up with it, that the cause for the dissolution of the marriage is something among the many factors that a court should take into account. And I don't believe it should be the major thing, although some of my clients who had very guilty spouses or bad acting spouses wanted to make it the major part of their case. There are other things that I think are terribly important to a judge when it comes to dollars and cents. But frankly, and I can only speak for Connecticut, I think the system is a reasonable system, that it is a factor to be considered. It's not dispositive, but it should be considered in the financial and custodial issues.
What do you tell? I mean, there's something I've come up with all the time was a person, I don't want the divorce, she's at fault, she had an affair, and why should I pay her alimony? I mean, or that she wants the divorce, I don't want the divorce, why should I pay her alimony? We even get the fault involved. I mean, how do you...
This is one reason why sometimes divorces take a while for resolution, because emotions are part of this deal here. This is not a negligence intersection. This is not a business deal, although it is a business deal. It's between two people who once loved each other and are now disappointed each other. And there are emotions involved. There's anger. There's sometimes bitterness. Sometimes there's punitiveness. Time heals, and that's why sometimes over a period of time, divorces take maybe a little bit longer than we'd like them to, because there are times that people aren't prepared to make good, solid decisions that are reasonably absent of the anger and emotions or guilt. And sometimes it's up to the lawyer to calm things down a little bit and slow things down, in the hope that the parties will make good, sound decisions as opposed to those that are predicated on emotion.
We're getting a 2-minute warning. We're a little bit under 2 minutes. I have to close the show. So I have some quick questions here. Do you think religious beliefs at all play into effect on fault or no fault?
I think that historically they did, and that was one of the reasons there was a great deal of opposition to no-fault divorce from certain religious groups. But those same religious groups were getting divorces, notwithstanding and participating in some of the nonsense that went on. You
and I have been practicing long enough now that we've been seeing now a whole new issue in gender issues coming involved with same-sex marriages, and I can film same-sex divorces now, and not a lot of that.
Absolutely.
Do you think fault or anything else? I don't see that personally. Is that
I don't see. I think
relates to that. I mean,
you're going to have the same issues.
Same issues.
Same issues. You're going to have the same things that are relevant, and the same things. You're going to have the same emotions, same anger, the same things that were on in heterosexual marriage are going to occur in same-sex marriage.
Final question, okay, which is the two mediators, two types of style of mediation. Do you think that the fault or issue comes into it? I guess when you're doing a value, I think that it probably fault enters into it. When I'm doing facilitated, probably less so.
I believe, and when I find
just got to watch the time. We got about 10 seconds.
That people resolve cases out of fear. The fear they have is that a judge, based upon certain wild cards, is going to do something that they don't want. That's why cases settle. Wild card and fault are synonymous.
Arthur, once again, thank you very much. It's been a pleasure having you on the show, and I always enjoy talking divorce with you. There's always learned something doing that one, and now that we're back in Western Connecticut, I guess, I always think of the two Jersey boys, the two Connecticut boys at this point, or two Connecticut men at this point.
That's right.
But it's been interesting learning and doing that, and it's always been inspiration to all of us, and I'm glad you had an opportunity to talk to you a little bit more about divorce today.
Well,
Thanks
thank
for coming.
you for having me.